Corporation. A corporation is an artificial being created by operation of law, having the right of succession and the powers, attributes, and properties expressly authorized by law or incident to its existence. Section 2. Unless otherwise indicated, all sections cited herein are from BP 68 or the Corporation Code. Attributes of a corporation. It is an artificial being. A corporation is a juridical entity that exists apart from its stockholders. It has its own set of rights and obligations as provided for by law. Technically, it has no physical existence, although it occupies the principal place of business. Being only a juridical entity, the physical acts of the corporation, like the signing of documents, can be performed only by natural persons duly authorized for such purpose by corporate bylaws or by a special act of the board of directors. A corporation, upon coming into existence, is invested by law with a personality separate and distinct from those persons composing it, as well as from any other legal entity to which it may be related. Number 2, it is created by operation of law. Mere consent of the parties to form a corporation is not sufficient. The state must give its consent either through a special law in case of government corporations or a general law, that is Corporation Code, in case of private corporations. A corporation comes into existence upon the issuance of the Certificate of Incorporation. Then and only then will it acquire juridical personality to sue and be sued, enter into contracts, hold or convey property, or perform a legal act in its own name. Number 3, it has the right of succession. Since one of the attributes of a corporation is that it is an artificial being with a distinct personality, the corporation's existence is unaffected by a change in the composition of stockholders. Its existence is limited only by the Articles of Incorporation. D has the powers, attributes, and properties expressly authorized by law or incident to its existence. A corporation has no power except those expressly conferred on it by the Corporation Code and by its Articles of Incorporation. Those which may be incidental to such conferred powers, those that are implied from its existence, and those reasonably necessary to accomplish its purposes. In turn, a corporation exercises said powers through its board of directors and or its duly authorized officers and agents. Being a creature of the law, its powers are limited by 1. The law, Corporation Code for general powers, and Section 37 to 44 for specific powers. Number 2, by the express terms of its Articles of Incorporation, as well as those essential or necessary to carry out its purpose or purposes under such articles. Section 36, last paragraph. And 3, by those necessary or incidental to its powers so conferred. Section 45. Classes of corporation. 1. Stock corporation. A stock corporation is a corporation which have capital stock divided into shares and are authorized to distribute to the holders of such shares dividends or allotments of the surplus profits on the basis of shares held. It is organized for profit. The governing body of a stock corporation is usually the BOD, except in certain instances like closed corporations. Note, a corporation is deemed to have the power to declare dividends, so long as the corporation has capital stock and there is no prohibition in its Articles of Incorporation or in its bylaws for it to declare dividends. Such corporation is a stock corporation. Number 2, non-stock corporation. All other corporations are non-stock corporations. A non-stock corporation is one where no part of the income is distributable as dividends to its members, trustees, or officers, subject to the provisions of the Code on Dissolution. It is not organized for profit. Its governing body is usually the Board of Trustees, or BOT. However, non-stock corporations may, through their Articles of Incorporation or their bylaws, designate their governing boards by any name other than as Board of Trustees. Section 138. Differentiate stock and non-stock. Stock have capital stock divided into shares. Non-stock, no part of income is distributable as dividends to its members or trustees. Stock are authorized to distribute to the holders of such shares dividends or allotments of surplus profits on the basis of the shares held. Under non-stock, any profit may obtain as an incident to its operations shall, when necessary or proper, be used for the furtherance of its purpose or purposes. Stock is composed of stockholders, while non-stock is composed of members. Stock corporation is made for profit, non-stock corporation is not for profit. Other distinctions: stockholders must act in meetings in person or by proxy. Under non-stock, members may vote by proxy, mail, or other similar means if provided in the bylaws. Under stock, cumulative voting in election of directors is provided by law, Section 24. Under non-stock, cumulative voting in the election of trustees is only available if provided in the Articles of Incorporation. Under stock, maximum of 15 directors except in merger or consolidation of banks, Section 14. Non-stock may be more than 15, Section 92. Stock, term of director is 1 year, Section 23. In non-stock, maximum term of a trustee is 3 years. Under stock, stockholders' meetings must be in the city or municipality where the principal office is located, preferably in the principal's office. Section 51. Under non-stock may be anywhere within Philippine territory. Under stock, one class of shares must always have complete voting rights. Non-stock, right to vote of members of any class may be denied in the Articles of Incorporation. Section 89. Stock, there is free transfer of shares. Membership is not personal to the stockholder. Non-stock, transfer of membership cannot be made without consent of the corporation. Section 90. Membership is personal. Stock may always vote by proxy. Non-stock, vote by proxy can be denied in the Articles of Incorporation. Stock, upon transfer of share, seller is no longer part of corporation. Transfer may only be subject to restrictions noted down in Articles of Incorporation, BL, and stock certificate, and must not be more onerous than right of first refusal. Non-stock, membership may be terminated according to causes provided in Section 91. Stock, residual assets are to be distributed to the stockholders upon dissolution. After payment of creditors, dissolution is effected through the methods provided in the Code. Non-stock, generally members are not allowed to participate in distribution of assets. Assets are to be distributed to such persons, societies, organizations, or corporations as may be specified in a plan of distribution, Section 94. Other corporations. Public corporation. Public corporation is one formed or organized for the government of a portion of the state. Its purpose is for the general good and welfare. Beyond cavil, a GOCC has a personality of its own, distinct and separate from that of the government. And the intervention in a transaction of the office of the President through the Executive Secretary does not change the independent existence of a government entity as it deals with another government entity. Polytechnic University of the Philippines versus CA. Not all corporations which are not GOCCs are ipso facto to be considered private corporations, as there exists another distinct class of corporations or chartered institutions which are otherwise known as public corporations. These corporations are treated by law as agencies or instrumentalities of the government which are not subject to the test of ownership or control and economic viability, but to different criteria relating to their public purposes, interests, or constitutional policies and objectives and their administrative relationship to the government or any of its departments or offices. Another is private corporation. Private corporation is one form for some private purposes, benefit, aim, or end. It may either stock or non-stock, government owned or controlled or quasi-public. The test to determine whether GOCC or private corporation. If a corporation is created by its own charter for the exercise of a public function, then GOCC. If by incorporation under the General Corporation Law, then private corporation. Another is closed corporation. Closed corporation is one whose articles of incorporation provided that 1. All issued stock, exclusive of treasury shares, shall be held by persons not exceeding 20. Number 2. All issued stock shall be subject to one or more specified restrictions on transfer. And 3. The corporation shall not list in any stock exchange or make any public offering of any of its stock of any class. Notwithstanding the foregoing, a corporation shall not be deemed a closed corporation when at least 2/3 of its voting stock or voting rights is owned or controlled by another corporation which is not a closed corporation, Section 96. And a corporation may be incorporated as a closing corporation except 1. Mining or oil companies, 2. Stock exchanges, 3. Banks, 4. Insurance companies, 5. Public utilities, 6. Educational institutions, and 7. Corporations declared to be vested with public interest. Section 96. Ordinary stock corporation versus closed corporation. Ordinary stock corporation has an article of incorporation with a general template. Closed corporation, the article of incorporation must provide A. Not to be held by more than a certain number of stockholders, not to exceed 20. B. Transfer restrictions allowed. C. Shall not be listed and shall not publicly offer. Further, a corporation which is not a closed corporation cannot own more than 75% of the outstanding capital stock. In the ordinary stock corporation, no limit to number of corporators allowed by authorized shares. Under closed corporation, not more than 20 according to the Articles of Incorporation. Under the General Corporation may list in Philippine Stock Exchange or PSE. Under the closed corporation may not list on PSE. Ordinary stock corporation in general, all businesses may be carried out by corporation. Under closed corporation, mining, oil, stock exchange, banks, insurance, public utility, educational, public interest cannot be organized as closed corporation. In the ordinary stock corporation, powers exercised by board, elected by stockholders. Under closed corporation, stockholders may manage affairs directly, subject to the same rights and liabilities of directors. In ordinary stock corporation, preemptive right subject to Section 39's limitation. Closed corporation, no limit to preemptive rights, thus includes sales of treasury shares and for acquisition of properties. Ordinary stock corporation, appraisal right must be for reasons listed in the code. Closed corporation, appraisal right can be for any cause and no need for URE, so long as the corporation would not thereby become insolvent. In the general stock corporation, dissolution must comply with all the requirements. Under closed corporation, any stockholder may petition for dissolution for stated grounds. Ordinary stock corporation, SEC may not regulate if purpose not illegal. Under closed corporation, SEC or SEC may intervene in management of corporation in case of deadlocks. Ordinary stock corporation, no classification of directors. Closed corporation may classify directors. Ordinary BOD elects directors. Closed corporation, Shareholders as directors directly elect officers if provided by the Articles of Incorporation. Ordinary stock corporation must have unrestricted retained earning to buy own shares. Closed corporation, no need for unrestricted retained earning to acquire shares if ordered by SEC in intra-corporate deadlock. Ordinary stock corporation, no arbitration in case of intra-corporate deadlock. Closed corporation, arbitration is allowed. Next is educational corporation. Educational corporation is one organized for educational purposes, Section 106. Except upon favorable recommendation of the Ministry of Education and Culture, the Securities and Exchange Commission shall not accept or approve the Articles of Incorporation and bylaws of any educational institution, Section 107. If organized as non-stock corporation, trustees of educational institutions organized as non-stock corporation shall not be less than 5 nor more than 15, provided, however, that the number of trustees shall be in multiples of 5. They shall classify themselves in such a way that term of 1/5 of them expires every year, Section 108. If organized as stock corporation, for institutions organized as stock corporations, the number and term of directors shall be governed by the provisions on stock corporations, Section 108. Next, religious corporation. Classes of religious corporation. Corporation sole, incorporated by one person, and religious societies incorporated by more than one person. Corporation sole is one form for the purpose of administering and managing as trustee the affairs, property, and temporalities of any religious denomination, sect, or church, or by the chief archbishop, bishop, priest, rabbi, or other presiding elder of such religious denomination, sect, or church, Section 110. A corporation sole has no nationality, but for the purpose of applying nationalization laws, nationality is determined not by the nationality of its presiding elder, but by the nationality of its members constituting the sect in the Philippines. Thus, the Roman Catholic Church can acquire lands in the Philippines even if it is headed by the Pope. Religious society or corporation aggregate. Corporation aggregate is a religious corporation incorporated by more than one person. Next is the eleemosynary corporation. Eleemosynary corporation is one organized for a charitable purpose. Domestic corporation is one form organized or existing under the laws of the Philippines. Foreign corporation is one form organized or existing under laws other than those of the Philippines and whose law allows Filipino citizens and corporations to do business in its own country and state. Corporation created by special laws or charter. Corporation created by special laws or charter are corporations which are governed primarily by the provisions of the special law or charter creating them. Corporation Code has supplementary application, Section 4. Subsidiary corporation is one in which control in the form of ownership of majority of its shares is in another corporation, the parent corporation. What is parent corporation? For parent corporation, its control lies in its power, directly or indirectly, to elect the subsidiaries directors, thus controlling its management policies. Holding company is a parent company which has no other business aside from the holding of the shares of its subsidiaries which it controls. Investment company, a parent company which holds shares in other corporations not for the purpose of controlling them, but merely to invest therein. What is corporation de jure? A corporation de jure is a corporation organized in accordance with the requirements of the law. Not every defect, however, precludes de jure corporation. As long as the mandatory requirements for incorporation are substantially complied with, a corporation de jure will be formed. How about de facto corporation? De facto corporation is a corporation where there exists a flaw in its incorporation. What is the rule on de facto corporations? The due incorporation of any corporation claiming in good faith to be a corporation under this code and its right to exercise corporate powers shall not be inquired into collaterally in any private suit to which such corporation may be a party. Such inquiry may be made by the Solicitor General in a quo warranto proceeding. General rule: the defect in the juridical personality of a corporation cannot be inquired into by private individuals, much less used as defense to avoid claims. Exception: in quo warranto proceedings brought on behalf of the state, where the main action is to question the validity or existence of such juridical personality. Requisites: there is an apparently valid statute under which the corporation may be formed. Number 2, there has been colorable compliance with the legal requirements in good faith. And 3, there has been user of corporate powers, that is, the transition of business as if it were a corporation. An association of persons cannot claim to be a corporation if it has not been issued a certificate of incorporation, since that fact belies the claim of good faith compliance with the requirements of the law. Corporation by Estoppel. A corporation by estoppel is where a group of persons misrepresent themselves as a corporation. They are subsequently stopped from claiming lack of corporate life in order to avoid liability. Also, a third party who had dealt with an unincorporated association as a corporation is precluded from denying its corporate existence on a suit brought by the alleged corporation on the contract. Effects of corporation by estoppel. As to liability, all persons who assume to act as a corporation, knowing it to be without authority to do so, shall be liable as general partners for all debts, liabilities, and damages incurred or arising as a result thereof. As to the defense of lack of corporate personality, when such ostensible corporation is sued, it is precluded from raising the defense of lack of corporate personality. As a third party, one who assumes an obligation to an ostensible corporation as such cannot resist performance thereof on the ground that there was in fact no corporation. The doctrine of estoppel applies to a third party only when he tries to escape liability on a contract from which he has benefited on the ground of defective incorporation. It does not apply to a third party who is not trying to escape liability from the contract, but rather is the one claiming from the contract. Corporation by estoppel versus Section 15, Rule 3. Corporation by estoppel clothes a non-entity with personality to sue a third person who seeks to evade liability in favor of the former. Under Section 15, Rule 3, the unincorporated entity may only be sued, but has no personality to sue. Corporation by estoppel merely creates a fiction whereby an association of persons is treated as a corporation only for purposes of exacting or enforcing liability. Section 15, Rule 3 does not concede to the association of persons the cover of a corporate entity even for such purposes of litigation. Corporation by estoppel for purposes of both protecting as well as imposing liability against third persons. Section 15, Rule 3, procedural remedy for drawing out the persons who will truly answer for the liability. How about de facto corporation versus corporation by estoppel? Under de facto, where all the requisites of a de facto corporation are present, then the defectively formed corporation will have the status of a de jure corporation in all cases brought by or against it, except only as to the state in a direct proceeding. Estoppel: if any of the requisites are absent, then the estoppel doctrine may be applied only if any of the parties is estopped from defending. A. The defendant association is estopped from defending on the ground of its lack of capacity to be sued, or B. The defendant third party has dealt with the plaintiff as a corporation and is deemed to have admitted its existence. Nationality of corporation. Place of incorporation test. The corporation is a national of the country under whose laws it is organized or incorporated. Domestic corporations organized and governed under and by Philippine laws. Foreign corporations organized under laws other than those of the Philippines and can operate only in the territory of the state under whose laws it was formed. However, they may be licensed to do business here. Section 123. Control test. A corporation shall be considered a Filipino corporation if the Filipino ownership of its capital stock is at least 60% and where the 60-40 Filipino alien entity ownership is not in doubt. Therefore, its shareholdings in another corporation shall be considered to be of Filipino nationality when computing the percentage of Filipino equity of that second corporation. Control test is applied in the following. 1. Exploitation of natural resources. Only Filipino citizens or corporations whose capital stock is at least 60% owned by Filipinos can qualify to exploit natural resources. Public utilities. No franchise, certificate of any other form of authorization for the operation of a public utility shall be granted except to citizens of the Philippines or to corporations or associations organized under the laws of the Philippines of at least 60% of whose capital is owned by such citizens. The Gamboa Ruling, 2011. The term capital in Section 11, Article 12 of the 1987 Constitution refers only to shares of stock entitled to vote in the election of directors, and thus, in the present case, only to common shares and not to the total outstanding capital stock, common and non-voting preferred shares. Compliance with the required Filipino ownership of the corporation shall be determined on the basis of outstanding capital stock, whether fully paid or not, but only such stocks which are generally entitled to vote are considered. For stock to be deemed owned and held by Philippine citizens or Philippine nationals, mere legal title is not enough to meet the required Filipino equity. Full beneficial ownership of the stock, coupled with appropriate voting rights, is essential. Thus, stocks, the voting rights of which have been assigned or transferred to aliens cannot be considered held by Philippine citizens or Philippine nationals. In 2012, Gamboa Ruling, the Supreme Court reversed its ruling stating now that the term capital is not limited to voting shares since the constitutional requirement of at least 60% Filipino ownership applies not only to voting control of the corporation but also to the beneficial ownership of the corporation. It is therefore imperative that such requirement apply uniformly and across the board of all classes of shares, regardless of nomenclature and category comprising the capital of a corporation. Preferred shares denied the right to vote in the election of directors are anyway still entitled to vote on the 8 specific corporate matters under Section 6 of the Corporation Code. Thus, the 60-40 ownership requirement in favor of Filipino citizens must apply separately to each class of shares, whether common, preferred, non-voting, preferred voting, or any other class of shares. In 2017, Gamboa Ruling, used in Roy III versus Herbosa, the Supreme Court explained its ruling in the 2012 Gamboa decision. It stated that the resolution of the 2012 Gamboa resolution, specifically its dispositive portion, did not modify the Gamboa Ruling decision in 2011. The Supreme Court clarified that the Gamboa decision already held in no uncertain terms that what the Constitution requires is full and legal beneficial ownership of 60% of the outstanding capital stock, coupled with 60% of the voting rights must rest in the hands of Filipino nationals. Thus, the purpose of determining compliance with the constitutional or statutory ownership, the required percentage of Filipino ownership shall be applied to both the A. total number of outstanding shares of stock entitled to vote in the election of directors, and B, the total number of outstanding shares of stock, whether or not entitled to vote. SEC Memorandum Circular Number 8 dated 20 May 2013. Section 1. Covert corporations. All corporations engage in identified areas of activities or enterprises specifically reserved, wholly or partly, to Philippine nationals by the Constitution, the FIA, and other existing laws, amendments thereto, and IRRS of said laws, except as may be otherwise be provided therein. Section 2. All covert corporations shall at all times observe the constitutional or statutory ownership requirement. For purposes of determining compliance therewith, the required percentage of Filipino ownership shall be applied to both. The total number of outstanding shares of stock entitled to vote in the election of directors. And number 2, the total number of outstanding shares of stock, whether or not entitled to vote in the election of directors. Note, this was the SEC memorandum put in question in the Roy III versus Herbosa case, and subsequently upheld by the court as constitutional. Grandfather rule. Method used when a domestic corporation has both domestic and foreign stockholders to determine whether or not said corporation is qualified to engage in a partially nationalized business. It involves the computation of Filipino ownership of a corporation in which another corporation of partly Filipino and partly foreign equity owns capital stock. The percentage of shares held by the second corporation in the first is multiplied by the latter's own Filipino equity, and the product of these percentages is determined to be the ultimate Filipino ownership of the subsidiary corporation. The grandfather rule must be applied to accurately determine the actual participation, both direct and indirect, of foreigners in a corporation engaged in nationalized activity or business. Sec Opinion, Ray Silahis International Hotel. The grandfather rule applies only when the 60-40 Filipino foreign equity ownership is in doubt. That is, in cases where the joint venture corporation with Filipino and foreign stockholders with less 60% Filipino stockholding or 59% invest in another joint venture corporation which is either 60 or 40% Filipino alien or 59% less Filipino. Stated differently, where the 60-40 Filipino foreign equity ownership is not in doubt, the grandfather rule will not apply. The control test can be, as it has been, applied jointly with the grandfather rule to determine the observance of foreign ownership restriction in nationalized economic activities. The control test and the grandfather rule are not, as it were, incompatible ownership determinant methods that can only be applied alternative to each other. Rather, these methods can, if appropriate, be used cumulatively in the determination of the ownership and control of corporations engaged in fully or partly nationalized activities. The grandfather rule, standing alone, should not be used to determine the Filipino ownership and control in a corporation, as it could result in an otherwise foreign corporation rendered qualified to perform nationalized or partly nationalized activities. Hence, it is only when the control test is first complied with that the grandfather rule may be applied. Put in another manner, if the subject corporation's Filipino equity falls below the threshold 60%, the corporation is immediately considered foreign-owned, in which case the need to resort to the grandfather rule disappears. On the other hand, a corporation that complies with the 60-40 Filipino to foreign equity requirement can be considered a Filipino corporation if there is no doubt as to who has the beneficial ownership and control of the corporation. In that instance, there is no need for this section or further inquiry on the ownership of the corporate shareholders in both the investing and investee corporation or the application of the grandfather rule. As a corollary rule, even if the 60-40 Filipino to foreign equity ratio is apparently met, by the subject or investee corporation, a resort to the grandfather rule is necessary if doubt exists as to the locus of the beneficial ownership and control. In this case, where based on the incorporation papers, the Filipino-owned corporation subscribed to 60% of the capital, while the foreign corporation subscribed to 40%, but the subscription of the former is only nominally paid up, and such corporation entered into a financial assistance agreement with the foreign-owned corporation. A further investigation as to the nationality of the personalities with the beneficial ownership and control of the corporate shareholders in both the investing and investee corporation is necessary. Fully, partially nationalized areas tent foreign investment negative list. I didn't understand that, but nationality requirement and industry. So nationality requirement 100% Filipino ownership, and this is for mass media, except recording, practice of profession, retail trade, cooperatives, private security agencies, small scale mining, utilization of marine resources in archipelagic waters, territorial sea, exclusive economic zone, as well as rivers, lakes, bays, and lagoons, ownership, operation, and management of cockpits, manufacture, repair, stockpiling, and or distribution of nuclear weapons, manufacture of firecrackers and other pyrotechnic devices. 80% Filipino ownership, and this is on private radio communication network. 75 Filipino ownership. This is for private recruitment, contracts for construction and repair of locally funded public works, except 1, infra projects under RA 7718 or BOT law, and number 2, foreign funded projects. Also contracts for construction of defense-related structures. 70% voting stock Filipino ownership, but may be reduced to 60, and the industry is bank, except rural banks. 70% Filipino ownership is for advertising. Now, for 60% capital stock Filipino ownership, these are manufacture, repair, storage, and or distribution of products and or ingredients requiring Philippine National Police clearance, that is firearms, ingredients used in making explosives, etc. In the manufacture, repair, storage, and or distribution of products requiring Department of National Defense clearance, manufacture and distribution of dangerous drugs, sauna and steam baths, massage clinics, and other like activities regulated by law because of risks posed to public health and morals. All forms of gambling, except those covered by investment agreements with PAGCOR. Domestic market enterprises with paid-in equity capital of less than the equivalent of $200,000. Domestic market enterprises which involve advanced technology or employ at least 50 direct employees with paid-in equity capital of less than the equivalent of 100,000 US dollars. Now, another is corporate juridical personality. It commences from the date the SEC issues a certificate of incorporation under its official seal. Doctrine of separate juridical personality. The concept is a corporation has a personality separate and distinct from that of its stockholders and members and is not affected by the personal rights, obligations, and transactions of the latter. A corporation, upon coming into existence, is invested by law with a personality separate and distinct from the persons comprising it as well as from any other legal entity to which it may be related. By this attribute, a stockholder may not generally be made to answer for acts or liabilities of said corporation and vice versa. That is in the case of Land Bank of the Philippines versus CA. Property. Stockholders have no claim on corporate property as owners, but mere expectancy or inchoate right to the same upon dissolution of the corporation after all corporate creditors have been paid. Such right is limited only to their equity interest, doctrine of limited liability. Although a stockholder's interest in the corporation may be attached by his personal creditor, corporate property cannot be used to satisfy his claim. Wise and Company versus Man Sun Lung, GR 46997. Liability for tort and crime. Being an entity with a separate juridical personality, a corporation can be held liable for torts committed by its officers for corporate purposes. PNB versus CA. Since a corporation is a person, or as a person is a mere legal fiction, it cannot be proceeded against criminally because it cannot commit a crime in which personal violence or malicious intent is required. Criminal action is limited to the corporate agents guilty of an act amounting to a crime and never against the corporation itself. Time Incorporated versus Reyes, DR 28882. Recovery of moral damages. A corporation can recover moral damages under Article 2219, number 7, if it was the victim of defamation. Filipinas Broadcasting Network versus Agu Medical and Educational Center. Note, Filipinas Broadcasting pointed out that the doctrine in Mambulao Lumber versus PNB to the effect that a corporation may recover moral damages for besmirched reputation is obiter dictum. Constitutional rights. Corporate entities are entitled to due process, equal protection, and protection against unreasonable searches and seizures. However, a corporation is not entitled to the privilege against self-incrimination. Bataan Shipyard and Engineering Company versus PCGG. Doctrine of piercing the corporate veil. Piercing the veil of corporate entity is an equitable remedy. The veil of separate corporate personality may be lifted when such personality is used to defeat public convenience, justify wrong, protect fraud, or defend crime, or used as a shield to confuse the legitimate issues, or when the corporation is merely an adjunct, a business conduit, or an alter ego of another corporation, or where the corporation is so organized and controlled and its affairs are so conducted as to make it merely an instrumentality, agency, conduit, or adjunct of another corporation, or when the corporation is used as a cloak or cover for fraud or illegality, or to work injustice, or where necessary to achieve equity or for the protection of the creditors. In such cases, the corporation will be considered as a mere association of persons. The liability will directly attach to the stockholders or to the other corporation. China Banking versus Dine Sem, GR 149237. If evidence of any such purpose is present, the courts will pierce the veil of corporate fiction. Aside from this general guideline, no hard and fast rule can be laid down to cover all cases where the corporate entity theory cannot be availed of, and each case will have to be considered on its merits. Grounds for application of the doctrine. The corporate fiction may be pierced if used 1. To defraud the government of taxes due it. 2. To evade payment of civil liability. 3. By a corporation which is merely a conduit or alter ego of another corporation. 4. To evade compliance with contractual obligation. 5. To evade financial obligation to its employees. Only in these and similar instances may the veil be pierced and disregarded to ward off a judgment, credit, to avoid inclusion of corporate assets as part of the estate of the decedent, or to escape liability arising from a debt, or to perpetuate fraud and or confuse legitimate issues, either to promote or to shield unfair objectives, to cover up an otherwise blatant violation of the prohibition against forum shopping. Test in determining applicability. Specifically, it is used in the following specific contexts. 1. The liability belongs to the corporations, but the plaintiff seeks to hold the individual liable. Mere controlling interest is not enough. There must be a clear showing that the corporate fiction is used to defeat public convenience, justify wrong, protect fraud, or defend crime. Note the following badges of fraud used as a shield to further an end subversive of justice, or 2, for purposes that could not have been intended by the law that created it, or 3, to defeat public convenience, 4, justify wrong, 5, protect fraud, 6, defend crime, or 7, to perpetuate fraud or confuse legitimate issues, or 8, to circumvent the law or perpetuate deception. Where the liability is personal to the individual and he seeks to evade it by hiding behind a corporate vehicle. Isabelo Kalinsangan and defendant Feli Transportation may be regarded as one and the same person. It is evident that Isabello Kalingasan's main purpose in forming the corporation was to evade his subsidiary civil liability resulting from the conviction of his driver Alfredo Carrillo. This conclusion is borne out by the fact that the incorporators of the Feli Transportation are Isabello Kalingasan, his wife, his son Dr. Kalingasan, and his two daughters. We believe that this is one case where the defendant corporation should not be heard to say that it has a personality separate and distinct from its members, when to allow it to do so would be to sanction the use of the fiction of corporate entity as a shield to further an end subversive of justice. Palacio versus Philo of Feli Transportation, GR 15121. Number 3, the instrumentality or alter ego rule. The elements of this modality are 1. Control, not mere majority or complete stock control, but complete domination, not only of finances but of policy and business practice in respect to the transaction attacked, so that the corporate entity as to this transaction had at the time no separate mind, will, or existence of its own. 2. Such control must have been used by the defendant to commit fraud or wrong, to perpetuate the violation of his statutory or other positive legal duty, or a dishonest and unjust act in contravention of plaintiff's legal rights. And 3. The aforesaid control and breach of duty must proximately cause the injury or unjust loss complained of. Circumstances rendering a subsidiary instrumentality an instrumentality. A. The parent corporation owns all or most of the subsidiary's capital stock. B. The parent and subsidiary corporations have common directors or officers. C. The parent corporation finances the subsidiary. D. The parent corporation subscribes to all the capital stock of the subsidiary or otherwise causes its incorporation. E. The subsidiary has grossly inadequate capital. F. The parent corporation pays the salaries and other expenses or losses of its subsidiary. G. The subsidiary has substantially no business except with the parent corporation or no assets except those conveyed to or by the parent corporation. H. In the papers of the parent corporation or in the statements of its officers, the subsidiary is described as a department or division of the parent corporation, or its business or financial responsibility is referred to as the parent corporation's own. I. The parent corporation uses the property of the subsidiary as its own. J. The directors or executives of the subsidiary do not act independently in the interest of the subsidiary, but take their orders from the parent corporation in the latter's interest. And K. The formal ledger requirement of the subsidiary are not observed. PNB versus Retracto Group. Successor corporation rule. This applies in instances where a corporation feigns dissolution or cessation but really continues in existence, organized under another name. This application of the rule figures prominently in labor cases where the prior entity seeks to evade its obligations to its laborers. Some telltale signs exhibited in Rolls versus CIR include 1. Consecutive dates of cessation and commencement of subsequent entity, 2. Ownership and control by former controlling stockholders, and 3. Turnover of assets. On the other hand, in Livise versus Binswager, GR 177493, 2014, the court pointed to the following: 1. Same officers, 2. Same office, and 3. Continuation of the business. Note, SME versus Digisman, GR 184517, allows for the defense of good faith in case of asset sales between a predecessor and successor corporation. In asset sales, the rule is that the seller in good faith is authorized to dismiss the affected employees, but is liable for the payment of separation pay under the law. The buyer in good faith, on the other hand, is not obliged to absorb the employees affected by the sale, nor is it liable for the payment of their claims. The most that it may do, for reason of public policy and social justice, is to give preference to the qualified separated personnel of the selling firm. In contrast with asset sales, in which the asset of the selling corporation are transferred to another entity, the transaction in stock sales takes place at the shareholder level, because the corporation possesses a personality separate and distinct from that of its shareholders. A shift in the composition of its shareholders will not affect its existence and continuity. Thus, notwithstanding the stock sale, the corporation continues to be the employer of its people and continue to be liable for the payment of their just claims. Furthermore, the corporation or its new majority shareholders are not entitled to lawfully dismiss corporate employees absent the just or authorized cause. This overturns the ruling in Manlimus versus NLRC, allowing for the defense of good faith in stock sales. Procedural considerations. The general rule is that both the individual sought to be held liable and the corporation must be impleaded at the first instance. This is in consonance with the tenets of due process and fair play. Hence, one cannot pierce the veil in order to acquire jurisdiction over a party. Pacific Rehouse Corporation versus CA. The principle of piercing the veil of corporate fiction and the resulting treatment of two related corporations as one and the same juridical person with respect to a given transaction is basically applied only to determine established liability. It is not available to confer on the court a jurisdiction it has not acquired in the first place over a party not impleaded in the case. Elsewise put, a corporation not impleaded in a suit cannot be subject to the court's process of piercing the veil of its corporate fiction. In that situation, the court has not acquired jurisdiction over the corporation, and hence, any proceeding taken against that corporation and its property would infringe on its right to due process. The implication of the above comment is twofold. 1. The court must first acquire jurisdiction over the corporation or corporations involved before its or their separate personalities are disregarded. And 2. The doctrine of piercing the veil of corporate entity can only be raised during a full-blown trial over a cause of action duly commenced involving parties duly brought under the authority of the court by way of service of summons or what passes as such service. Kukan versus Reyes. A sheriff may not pierce the corporate veil because such power only belongs to the court. The only exception recognized by jurisprudence is when it is a labor case involved. When an aggrieved laborer is under or unable to touch the properties of the corporation, the labor arbiter may thereafter amend its decision by ordering that the properties of the individual be levied. Incorporation and organization. Promoter. Promoters are persons who, acting alone or with others, take initiative in founding and organizing the business or enterprise of the issuer and receives consideration therefor. Liability of promoter. General rule, the promoter binds himself personally and assumes the responsibility of looking to proposed corporation for reimbursement. Exception. Express or implied agreement to the contrary. Number 2, novation, not merely adoption or ratification of the contract. Liability of corporation for Promoters Act. General rule. A corporation is not bound by the contract. A corporation until organized has no life and no legal existence. It could not have had an agent, the promoter, who could legally bind it. Cagayan Fishing Development versus Sandico. Steps in incorporation. Promotional stage, drafting articles of incorporation, filing of articles, payments of fees, examination of articles, approval or rejection by SEC. Finally, the issuance of certificate of incorporation. And this certificate of incorporation will be issued if SEC is satisfied that all legal requirements have been complied with and there are no reasons for rejecting or disapproving the Articles of Incorporation. It is only upon such issuance that the corporation acquires juridical personality, Section 19. Should it be subsequently found that the incorporators were guilty of fraud in procuring the certificate of incorporation, the same may be revoked by the SEC after proper notice and hearing. Number and qualifications of incorporation. Natural persons, any number from 5 to 15. C. Majority or residents of the Philippines. D. Each incorporator must own or be a subscriber to at least one share of the capital stock or the corporation. A one-person corporation is a corporation with a single stockholder who must be a natural person, trust, or an estate. It must not be confused with a corporate soul. The creation of a one-person corporation or OPC is provided in Title 13, Special Corporations of Republic Act number 11232, also known as the Revised Corporation Code. The guidelines as provided in SEC Memorandum Circular number 7, Series of 2019, are discussed below. Corporate name, one-person corporation shall indicate the letters OPC either below or at the end of its corporate name. Primary purpose, principal office address, the terms of existence, names and details, authorized, subscribed, and paid up capital. A one-person corporation shall not be required to have a minimum authorized capital stock except as otherwise provided by special law. Further, unless otherwise required by applicable laws or regulation, no portion of the authorized capital is required to be paid up at the time of incorporation. Officers, the single stockholder shall be the sole director and president of the one-person corporation within 15 days from the issuance of its certificate of incorporation. The one-person corporation shall appoint the officers and inform the SEC of such fact within 5 days from the appointment. The officers are treasurer, corporate secretary, and other officers as it may deem necessary. Bond requirement, as a rule, there is no bond requirement for a single stockholder in a one-person corporation. However, in the event that the single stockholder also appoints himself or herself as the corporate treasurer, he must post a bond. Subject to renewal every 2 years as it may be required upon review of the annual submission of the AFS, certified under oath by the company's president and treasurer. The bond is a continuing requirement for so long as the single stockholder is the self-appointed treasurer of the one-person corporation. The bond may be canceled upon proof of appointment of another person as the treasurer and filing of amended form of appointment of officers. Corporate name, limitations on use of corporate name, must not be identical or deceptively or confusingly similar to that of any existing corporation or to any other name already protected by law. Not patently deceptive, confusing, or contrary to existing laws. The policy underlying the prohibition against the registration of a corporate name, which is identical or deceptively or confusingly similar to that of any existing corporation, or which is patently deceptive or patently confusing or contrary to existing laws, are the avoidance of fraud upon the public, which would have occasion to deal with the entity concerned, the prevention of evasion of legal obligations and duties, and the reduction of difficulties of administration and supervision over corporations. To determine whether a given corporate name is identical or confusingly or deceptively similar with another entity's corporate name, one must evaluate corporate names in their entirety. The corporate name shall contain the word corporation or incorporated or the abbreviation Corp or INC, respectively. Business or trade name, which is different from the corporate name, shall be indicated in the Articles of Incorporation. A company may have more than one business or trade names. Change of corporate name requires the amendment of the Articles of Incorporation, majority vote of the board, and the vote or written assent of stockholders holding 2/3 of the outstanding capital stock. Amendment of a corporation's Articles of Incorporation to change its corporate name does not extinguish the personality of the original corporation. It is the same corporation with a different name, and its character is not changed. Consequently, the new corporation is still liable for the debts and obligations of the old corporation. Corporate term, general rule of corporation shall exist for a period not exceeding 50 years from the date of incorporation. Exception, the corporation is sooner dissolved when the period for the corporation's existence is extended, not exceeding 50 years in any single instance. An extension requires an amendment of the Articles of Incorporation subject to the exercise of appraisal rights by the dissenting stockholder. Extension may not be made earlier than 5 years prior to the original or subsequent expiry date, except if the SEC determines that there is justifiable reason for an earlier extension.